Hello everyone. Welcome back to our channel, U.S. Immigration News. We hope you're doing great. If you're interested in this topic, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe. And don't forget to push the notification bell for an upcoming video. The recent Supreme Court decision carries profound implications for U.S. immigration law, reinforcing the balance of power between the executive branch, Congress, and the judiciary. As the Constitution grants Congress the power of the purse, it controls federal spending and allocates funds, ensuring that the executive branch cannot unilaterally withhold or redirect these resources. However, the executive branch's attempt to withhold these funds was deemed unlawful by the Supreme Court, which ruled that such actions undermine Congress's authority. This ruling is particularly significant for immigration, as it establishes a critical precedent. It signals that the executive branch cannot alter immigration policies without oversight from Congress and the judiciary. With multiple immigration-related cases, including those concerning deferred action for childhood arrivals and asylum policies, expected to reach the Supreme Court soon, this decision offers hope that future executive overreach can be curtailed. This landmark ruling highlights the judiciary's role in maintaining checks and balances, ensuring that immigration policies are implemented fairly and within legal bounds. The new flexibility in the 212 waiver, a game changer. Another major update in immigration policy involves the 212 waiver, often referred to as a magic waiver. This waiver allows individuals deemed inadmissible due to health issues, prior convictions, or the 3 and 10-year bars for unlawful presence to obtain a non-immigrant visa. Historically, consular officers were bound by previous decisions when adjudicating waiver applications. A prior denial often negatively impacted subsequent applications. However, under new guidance, consular officers now have greater flexibility to make independent determinations based on the facts and circumstances of each application. This means that even if your 212 waiver was denied previously, you can reapply and have your case reviewed anew without the shadow of prior denials. To increase your chances of success, it's essential to cite the new guidance, mention the updated standards in your application, demonstrate eligibility, highlight any new evidence or changes that strengthen your case. This change offers renewed hope to many applicants who previously had no viable path to securing a waiver. Lawful entry and adjustment of status, unlocking green card opportunities. Lawful entry into the United States, even under limited circumstances, can significantly impact an individual's eligibility for adjustment of status. Under Section 245 of the Immigration and Nationality Act, individuals who enter the U.S. lawfully, even if they later overstayed or worked unlawfully, may still be eligible to adjust their status and obtain a green card. For instance, being waived through a port of entry or entering with a valid visa. But falling out of status does not negate the fact that the initial entry was lawful. This lawful entry opens a door for many immigrants to pursue adjustment of status, a critical opportunity for those who may have believed their options were exhausted. Green cards, not a guaranteed stay. J.D. Vance emphasized that permanent residency, granted through a green card, is not an indefinite guarantee. Green cards can be revoked under certain conditions, such as criminal activity. Engaging in criminal behavior can lead to the revocation of residency status. Prolonged absence. Extended time outside the U.S. may signal abandonment of residency. Failure to comply. Violating immigration regulations can result in deportation. Vance highlighted that these provisions are not merely about national security, but also about determining who becomes part of the American national community. Trump's Gold Card proposal. Wealth as a pathway to citizenship. Trump's Gold Card initiative, which proposes allowing foreign nationals to purchase the right to live and work in the U.S. for a $5 million fee, has sparked intense debate. The Gold Card would offer green card privileges and a pathway to citizenship, potentially replacing the EB-5 immigrant investor visa, which currently requires job creation in the U.S. While Trump argues that this proposal would attract top international talent and generate billions in revenue to help reduce the national debt, critics contend that it raises concerns about tying immigration opportunities to wealth. The Gold Card proposal introduces a new dimension to the immigration debate, questioning whether financial contributions should influence immigration eligibility. shaping the future of U.S. immigration policy. These developments, the Supreme Court's ruling on executive power, the updated 212 waiver guidelines, and Trump's controversial gold card proposal are collectively reshaping the U.S. immigration landscape. Green card, but better. Trump says his gold card to U.S. citizenship will go on sale very, very soon. President Donald Trump, in his first joint address to the U.S. Congress since returning to the White House in January, introduced a new immigration initiative called the Gold Card. The proposal offers a path to American citizenship for immigrants willing to pay $5 million. The president described the new permit as like the green card, but better and more sophisticated. Speaking in a primetime address at the House of Representatives on Tuesday night, Trump said the initiative is part of efforts to balance the federal budget. We have developed in great detail what we're calling the Gold Card, which goes on sale very, very soon, he said. For $5 million. We will allow the most successful job-creating people from all over the world to buy a path to U.S. citizenship. It's like the green card, but better and more sophisticated. These people will have to pay tax in our country, he added, receiving loud applause. On February 25th, Trump formally unveiled the Gold Card visa plan, which is set to replace the EB-5 visa program. The EB-5 program, established by Congress in 1990, allowed foreign investors to obtain U.S. residency by investing around $1 million in businesses that create at least 10 jobs. Under the new system, the Gold Card will be available to what Trump termed high-level people with no restrictions based on the applicant's country of origin. However, candidates will undergo vetting. Trump emphasized that the initiative aligns with his administration's broader immigration policy. While we take out the criminals, killers, traffickers, and child predators, we will now bring in brilliant, hardworking, job-creating people, he said. They're going to pay a lot of money, and we're going to reduce our debt with that money. The president also praised what he called the most sweeping border and immigration crackdown in American history. He highlighted his administration's efforts to deport thousands of undocumented immigrants, including Indians, and criticized previous calls for new legislation to secure the border. The media and our friends in the Democrat Party kept saying, "We needed new legislation. We must have legislation to secure the border." But it turns out all we needed was a new president, he remarked.
Major shifts in the U.S. immigration policy. Supreme Court ruling 212 waiver flexibility and Trump's gold card proposal. The recent Supreme Court ruling has a profound implications for U.S. immigration law, reforming the balance of power between Congress, the executive branch, and the judiciary. The Constitution grants Congress the power of the purse, giving it authority over federal spending and resource allocation. The Supreme Court ruled that the executive branches attempt to withhold or divert these funds was lawful, emphasizing that immigration policy changes cannot occur without congressional and judicial oversight. This landmark decision set a critical precedent, especially with more immigration-related cases, such as those concerning deferred action for child rule arrival and asylum policies expected to reach the Supreme Court. The ruling signals that future executive overreach in immigration matters can be challenged, offering hope for a more balanced and legally sound immigration system. A major change in immigration policy involves the 212 waiver, which allows individuals deemed inadmissible due to health issues, prior convictions, or unlawful presence to obtain a non-immigrant visa. Previously, consular officers were bound by prior decision and a denial of the negatively impacted future applications. However, under new guidance, consular officers now have a greater discretion to independently evaluate waiver applications based on current circumstances. This change offers renewed hope to applicants who can now reapply without being prejudiced by previous denials. Lawful entry into the United States, even in limited circumstances, can also impact an individual's eligibility to adjust status and obtain a green card under Section 245 of the Immigration and Nationality Act. Individuals who are entered lawfully, even if they later overstayed or worked unlawfully may still pursue adjustment of status. For example, being waived through at a port of entry, entering with a valid visa maintains eligibility for a green card. Vice President J.D. Vance recently emphasized that green cards are not permanent guarantees and can be revoked under certain conditions, such as criminal activity, prolonged absence, or a failure to comply with immigration regulations. Meanwhile, former President Donald Trump's gold card proposal, which would allow wealthy divorcees to purchase a path to U.S. citizenship for $5 million, has sparked intense debate. These developments collectively reshaped U.S. immigration policy and sparked critical discussions about the nation's future approach to immigration.